recorded. My name is Istvan Harkai. I am a senior lecturer at the University of Szeged Faculty of Law and Political Sciences and also a participant of this Age 2020 Recreating Europe program. And I have the honor to lead this discussion about the parody exception and the pastiche exception. And we have three panelists, three discussants: Julien Cabay, if I pronounce his name correctly, Philipp Homar, and Kacper Szkalej. And I was asked to keep the time limit, which will be 10 minutes per discussant, because we are only three in this panel, so we will have time. And after every panelist shared his or her thoughts about the limitations and exceptions, and specifically the parody and quotation, we will have around 10 minutes for questions and comments. I have already one comment, but I will keep it until the end of this panel. So I would like to pass the floor to Professor Julien Cabay, who is an associate professor at the Université Libre of Brussels and at the University of Liège. And he's also an invited professor at the Universities of Strasbourg and Leuven. And he's also an affiliate researcher at the Digital Law Center, University of Geneva. Professor Cabay, the floor is yours.
Thanks a lot. So I'm very happy to be here. I will just try to share my screen in order to show you a few things that I'd like to share with you today. Just have to find out where is my...
It's at the bottom of the page.
Yeah, I know, but I can't. I can't find the right one. I'm sorry about this. Where is it? Wait a minute, because I'm sorry about this. I get it, but not the right one. So I understand why. Okay, here it is. Okay, so here I am. So I'm sorry about this. So it's complicated to talk about parody and quotation and all these things. So I'd like to, because there are so many things to say. So actually, I'd like to share with you a personal experience. Back in 2012, I was in New York. I was attending a corporate law class and at Columbia Law School. And while discussing fair use, actually, we started commenting on this. And we were envisaging its status as a parody. And I was puzzled because I was thinking, I don't get it. Why are they talking about parody? So the most surprising to me was that when I looked around, I noticed that all American guys in the rooms were shaking their head, showing disapproval or either nodding because they didn't agree with the parody status of this. And basically, they actually did get it. And I was the only one scratching his head, like with the question, why would that be a parody? So for those of you who share with me somehow the same feeling of loneliness I had at the time, the reason is probably because you're not familiar with Dr. Seuss' The Cat in the Hat. As I would figure out later, this book is actually a classic in children's literature that every American kid has read in its early days. In other words, The Cat in the Hat is a common reference for Americans. And it is self-speaking for anyone in the US. This is why they could discuss whether the cat is not in the hat is a parody or not, without any further explanations. And this is also why, as a Belgian guy freshly arrived on the other side of the Atlantic, I did not get it. So this little story actually illustrates perfectly the point I want to make here. In the 5 minutes I have, I assume I have a little bit less than what is offered, so maybe we'll have more time for discussion. That's great. So the parody as such is a topical figure of what's called in general intertextuality. The term was coined first by Julia Kristeva, who stressed out that every text is constructed as a mosaic of quotations. The reference here to the text can be brought into every type of material, as intertextuality is present in every field of artistic creation. It's quite easy to understand how intertextuality comes up with copyright law, since copyright protection can lie in small pieces of an author's work that can be used by another author for the purpose of creating something else. And from a copyright law perspective, the type of copying would amount to infringement, except where a valid defense can be raised. What, however, makes intertextuality different from mere plagiarism and infringement lies in the relation between the two works. Here, in the field of intertextuality, the relation is not meant to be concealed. To the contrary, intertextuality performs its aesthetical function exclusively and only to the extent that it is perceived as such by the observer. It supposes, therefore, a certain command by the observer, a command that is desired or assumed by the author, the creator. In the field of quotation, the recognition of the presence of intertextuality is traditionally eased by the author, who will mention the source, like on this slide. This often performs additional tasks, like evidencing the reliability of the information used or the authority of the critics. But what about parody? Mentioning the source is not common in the field of parody, and the Court of Justice in Dekmin confirmed that the concept of parody should not be subject to such a condition. Does it mean that a parody can exist where the source is not identified? Still in Dekmin, the Court of Justice stated that a parody must be regarded as an autonomous concept of EU law and interpreted uniformly throughout the European Union. It considered that its essential characteristics are, first, to evoke an existing work while being noticeably different from it, and secondly, to constitute an expression of humor or mockery. The application of this definition is, however, left to the national judge, who will have to take into account all the circumstances of the case in order to strike a fair balance in such application. To evoke an existing work while being noticeably different from it, this is the first condition, seems to me impossible where the work that is evoked is unknown from the observer. So in a previous study of mine and my colleague Maxime Lambrecht, based on a thorough analysis of the case law in Belgium and France, we concluded that it seems that the target of the parody has to be to a certain extent famous at the time of the parody. That conclusion was supported by the case law, the literature, and by the fact that we could not identify one single decision finding a lawful parody making use of an unknown work. And similarly, in his opinion in Dekmin, the Advocate General Cruz Villalon seemed to assume that the parody could be legitimate where there is an alteration of pre-existing work, which is sufficiently recognizable to the public at which that criticism is directed. Which leads me to my main point. The qualification of parody is highly subjective, in the sense that it is subject to a relation and a contextual assessment from the point of view of the observer. But here the idea of a subjectivity infusing the notion is not akin to the one that attracts criticism, like in the assessment of originality, for example, in particular in member states where the aesthetic or artistic value were relevant before Kofemel. It is not either the type of unwelcome subjectivity one would see in the qualification of a hyperlink as a communication to the public after GS media. No, here the subjectivity is inherent to the concept of parody because its very existence from an aesthetic and legal standpoint depends on the observer, his or her knowledge, his or her understanding. And even if the Court of Justice in Libre stressed out the need to remove subjectivity from the assessment of copyright protection, there's still room for the type of subjectivity at stake in the intertextuality. In that regard, in Pelham, through reading the quotation exception in the light of the freedoms of the arts protected under Article 13 of the Charter of Fundamental Rights, the Court of Justice emphasized that the application of the exception was with the work from which the sample was taken, which supposes that it is possible to identify the work concerned by the quotation at issue, which leads to the obvious and difficult question, by whom? So it is impossible to answer that question here, but to conclude, I think it is worth recalling that original works, including parodies, are intended to an audience. Sometimes this audience can be that wide that it covers the population of a whole country as big as the US, with a common culture well anchored. Sometimes to the opposite, this audience will be very local in place and time. It can even be children. But whatever the audience, it will always be decisive to give it a place in the analysis of a parody, as it is necessary in order to address, in one particular case, the fair balance between the protection of copyright and the freedom of expression and the arts. This is why autonomous and uniform interpretation will never lead to autonomous and uniform application. At least I hope so, for the sake of the arts. This is the point I wanted to make here, and I'm very happy to have questions and discuss some of the cases I just showed, particularly the Belgian ones. So the floor is yours. Thanks.
Thank you very much for this very interesting presentation. And I would like to pass the floor now to Philipp Homar, who is a full professor of intellectual property law at the Johannes Kepler University of Linz. And he's also a senior lecturer, senior scientist at the Center for IP, Media and Innovation Law at the Danube University of Krems. Philipp, the floor is yours.
Thank you for handing over the floor. I want to start right away, and my approach today is to discuss some of the recent case law in Austria that is concerning parodies and quotations. So I want to start right away and want to start with the parody exception in the Austrian copyright system, because I can be quite short on the parody exception, because we still don't have a parody exception transposed in the Austrian copyright law, which is similar to the situation in Germany. This will, of course, change as soon as we've transposed the copyright directive in the digital single market, which we still don't have, and I think this will still take some time. But right now, the situation is in Austria, we don't have an explicit parody exception, which means that parodies are in the Austrian system dealt with under the doctrine of free use of independent works. You may be familiar with this standpoint also from the German copyright law, because it was in the background of the referral in the case Pelham. And that's also how the Austrian courts are dealing with parodies, if they are to be deemed as independent new works, which means that they are sufficiently independent. Actually, the Court of Justice says in evaluating if this new work is sufficiently independent, we also have to take into account the fundamental rights of freedom of speech and freedom of the arts. And if this leads then to the situation to say, acknowledging the freedom of speech, we have to say this new work is sufficiently independent to the old work, then the use is admissible, and the parody does not require the consent of the author of the original work. In this case, you see one example for parody. We actually don't have many cases on parodies in the Austrian system. In this case, it was about a governor of a state in Austria. You see the picture of her on the left-hand side, and she was making an election advertisement for kindergartens. And on the right-hand side, you see a parody of this photograph, because this governor you see here was also liberal on abortion policies, and an anti-abortionist group was making the parody on the right-hand side and was taking one child out of the picture, because the text is saying that this child did not survive the liberal policy on abortion supported by this person. And the Austrian Supreme Court said this was a legitimate way of parody, because it is not untrue or defamatory. So also some acknowledgements we would need to consider under the Deckman case that the Austrian court was taking into consideration here. And it also said that actually the parody does not undermine the economic interests involved here in this case. I want to now switch to the quotation exception, as we also want to talk about the status of the quotation exception. And the situation in Austria here is that we, of course, have transposed a quotation exception. And since 2015, we have it in a way that is comprising both a general clause, which is generally stating when a quotation is admissible. And then we additionally have a demonstrative list of specific cases in which a quotation is to be deemed as admissible. So this is the basic approach of the Austrian legislator for dealing with quotations. And I now want to provide a short overview of case law that's mainly targeting two aspects in the press debate and in the political debate, because we had quite a bunch of cases that is concerning these two aspects of using third-party content in the press debate and also in the political debate. And when it comes to citing pictures in critical reports, the Austrian Court of Justice is putting an emphasis quite much on the purpose of the quotation, but because it says that not every purpose of the quotation of third-party content, and in particular it was about using photos of third parties, he's saying not every purpose of citation also justifies the means. So the point is very much on whether the work that is cited is enabling the fundamental rights to free speech. And you see the differentiation here in the cases where the outcome was that the citation was permissible. They were mainly about that criticism was enabled, the citation was enabling the reader to form an own opinion. And also in many cases, the court refers to that it just would not have been possible without the citation to transmit the meaning that was now transmitted by using the work. Inadmissible are any citations which, on the other hand, exceed the amount that is deemed to be admissible under the fundamental right of free speech. And the Austrian Court of Justice says the line that has to be drawn here is whenever a work is only used as eye-catcher, as mere illustration, and if it is just not conferring any additional informative value, then these are citations which are not admissible under copyright law. And to make this visible with concrete examples, you see here one case. It was about a photo on the left-hand side, which is showing the head of the Green Party, the head of the parliamentary club of the Green Party, to be precise. So it's a member of the Austrian Parliament who was posting a photo against hate speech. It was directed against people posting hate speeches, and another political party took a part out of the photo and was using it for criticizing the politics of this member of the parliament. And the Court of Justice in this respect said this was not admissible. This is not an admissible citation because I've provided an overview here of the reasoning. I can't go into detail because of time reasons, but ultimately the Court of Justice said there was just no recognizable interaction with the cited work. And this rather leads to an undue impairment of the plaintiff's interest because the context in which it's used. So it was used in a political context, which was deemed to be defamatory in its nature because this content that was now expressed with the parody or the citation was just not true. So it was defamatory to the copyright holder in this aspect. Where the outcome was different was this example. You see the Austrian Chancellor in this picture on the left-hand side. They posted this photo on the Facebook channel of the Austrian Chancellor's website, and then they switched the photo in the background here. So you see that they inserted another photo in the background. It was a third-party photo, and the thing is, this was not a problem in this aspect. So it seems that the copyright holder of this photo in the background was quite okay with the photo being. Another political party was reporting about the media practices of the Chancellor and was saying that the Chancellor is retouching these photos and is putting some content, some third-party photo into this picture. And then this other party was sued by the copyright holder of this photo with the nature motive. And in this aspect, the Court of Justice says this is an admissible citation because the photograph with the nature motive had a quotation and evidence function, since a mere verbal description would not have had the same effect. So in this aspect, it was an admissible citation. To sum it up, I think in the Austrian system, both the parodies and also the citations come down to a case-by-case assessment. It is very much down to the purpose of the quotation in the specific fact, and the line that has to be drawn here according to the Austrian jurisprudence is whether we can deem it as quotation or as a mere illustration. Whenever it's a mere illustration, then this is not to be deemed as admissible under the Austrian quotation exception. I think what we also can say is that the lack of indication of the source, which is of course also actually a requirement under the Austrian citation exception, the lack of the indication of the source is actually dealt with rather generously, because the cases that I've shown, I think you could have argued in this aspect that these are no citations because there is no indication of the source. So I think you could actually have quite easily argued that these are all of them are not admissible citations because the source is lacking, but this did not affect the outcome in the court cases. So I think the Court of Justice is putting most of the emphasis on the purpose of the citation, and the lack of indication is actually not dealt with so strictly. So this was my input from the Austrian system, and I look very much forward to the discussion.
Thank you very much, Philipp. And now we will go to the next one, the last presenter, Professor Kacper Szkalej, who is a researcher at the University of Uppsala, also a guest lecturer at the Universities of Stockholm and Lund, and a lecturer at the KTH Royal Institute of Technology. Professor Szkalej, the floor is yours.
Thank you very much, Istvan. It's a great pleasure to be here. I will set up my screen that you should be able to see right now. I'd like to really continue on Philipp's track to talk about parodies in Sweden, and specifically on something that I should probably call the Swedish parody doctrine, or the parody principle. It was established in 2019 and is still under development. To describe what this doctrine does, I've given my very concise presentation a subtitle: Ensuring Legal Certainty Through Legal Flexibility. As a contextual remark about the Swedish copyright system, we position ourselves on the same end of the spectrum as traditional European copyright law. We all know, notwithstanding the developments before the CJU, rights are broad and limitations are narrow and are intended to be construed narrowly, and this ensures legal certainty, unless it is a parody. So, stepping in the shoes of a formalist, a little bit like in Austria, Swedish copyright law does not have an adopted parody provision in the catalog of limitations in the Copyright Act. Now, I don't want to say that we opted to exercise the discretion in Article 5 of the InfoSoc Directive and not implement Article 5.3k. Rather, parodies are simply not even mentioned in the preparatory works related to implementation of the directive. But they are permitted under the Swedish version of the Freie Benutz and Free Use provision, which is in section 4.2 of the Act, and which states that if an individual has created a new and independent work in free connection to a work, their copyright shall not be subject to the rights in the original work. And it's been like this since at least the adoption of the current Act in 1960, as the preparatory works to that Act expressly recognize that it is a tradition to accept parodies as permitted uses in copyright law. And at the time, space was allocated in section 4 of the Act. And prior to Deckman, or even the InfoSoc Directive, no court ever went to the bottom of the question whether parodies need to be an individual or new work or not. The preparatory works do not really, or they are unclear on this point, since they merely accept that parodies are permitted under the Copyright Act, and they say that in the context of a discussion on Section 4. So it has been really open to discussion, and some early scholarship, even before Deckman, would also point this out, that there is room for an argument that parodies need not be original. But this was open for debate, and the three cases that we have before the InfoSoc directive and before the Deckman case did not really, as I said, go to the bottom of this. And in July 2019, the Patent and Market Court of Appeal cast light on this question in the so-called metal pole case, which, well, awkwardly had familiar circumstances that concerned periodical use on the internet of an unpublished part of a video protected by neighboring rights that were recorded by a well-known politician. And essentially, there's a lot of circumstances in this case, and actually a few more exceptions that the court was considering. But as far as parodies were concerned, the court stated that the failure to mention parodies in the preparatory works during implementation of the InfoSoc directive did not mean that the legislator intended parodies to not exist after implementation. Rather, the legislator desired to maintain parodies as permitted uses under the already set up framework. But following Deckman, as Julien already explained, the court made clear that parodies constitute an autonomous concept of EU law, which must be given a uniform interpretation and need not be original. And then following the CJU's case law on the concept of work and originality, it's referred here to InfoPack and Levla Hengelo, the existing order under Section 4 might conflict the CJU's clarification of how EU law is to be construed. And for that reason, an understanding that parodies must actually constitute a new and independent work cannot be applied. So the court instead applied the Deckman ruling in the context of Section 4, and basically created a new limitation, you could say, in a very unlikely place, as a kind of a prong of Section 4 that is based on Deckman and simply accepts the so-called, well, let's call it EU concept of parody. And this approach was repeated last year in October by the district court in another parody case that concerned a well-known work which was used on the cover of a book and a few other places, called the Swedish Tiger. And this decision has been appealed, so it's actually now before the appeals court. But what's interesting here is, except the fact that the court did expressly apply the reasoning of the metal pole case, that the court also referred to the three-step test and made an assessment of whether parodies should be allowed. The assessment isn't really systematic of going through all the steps, but an overall assessment was made, and the court concluded that the three-step test does not preclude accepting parodies as permitted uses. So I guess my time is running out. So by way of a closing remark, the question is really whether we should preserve this newly established Section 4.2 order in Deckman livery, or whether we just introduce an actual limitation in the catalog in Chapter 2. The timing is obviously right for this question, since we are still working on figuring out what to do with Article 17 and the DSM directive in general, where we are going to be late. I've stated in a different context that there are good reasons for including a new provision in the catalog of limitations to ensure transparency in the system, so that it is clear what is allowed and what is not allowed. But there are also very good, maybe even better reasons to let parodies stay where they are right now. And this has to do with Section 11 of the Copyright Act, which makes clear that the catalog of limitations does not apply to moral rights. So stated simply, moral rights take precedence over the limitations that we have. And obviously, parodies do challenge protection conferred by moral rights. Almost all of the cases, the few cases that we have, includes moral rights claims. So a conflict cannot be avoided in these kind of cases, and letting parodies remain in Section 4, the way it has been developed by the court now, probably provides more space for at least a transparent balancing act of the different interests and fundamental rights that are at stake than what the second chapter of the act will allow if we literally apply this ceiling that is imposed by Section 11. And I think that in Sweden, this space might actually be needed because copyright also enjoys sui generis, so to say, constitutional protection. So there's the additional edge from a fundamental rights perspective that we or accept the fundamental rights balancing that we're used to see in the deciduous case law. And if we instead let the assessment be governed by Section 11 or having regard to Section 11, I think that in practice, every case that involves parodies will instead focus on the technicalities around or related to moral rights. That is because the courts normally are very loyal to the wording of an adopted provision, even if the metal pole case might imply otherwise. Thank you very much.
Thank you very much for the presentations to Professor Szkalej. Let me give you just one comment very briefly. Hungary has just implemented the whole CDSM directive and the parody exception included, and it has just entered into force today. So that was my short comment, and we have two questions, if I saw correctly in the chat room. On one hand, to Julien, there is a question, how are to handle cases where the supposed parody is communicated to a broad geographical audience? And on the other hand, we have another question from Julia Reda regarding the parody exception. It sounds like that. Would you consider the standard of getting the reference is different for pastiche? And perhaps this could also be subsumed under the quotation, but not German courts. So the floor is yours to answer the questions, can be found in the chat room.
Thank you. I guess I may have a word on the two questions, one which is directly directed to me by Lionel. And regarding Lionel's question, that's a tricky question. So in practice, the problem would be if we do have conflicting decisions or conflicting cases in different countries with different judges. For example, that parody would go to judges, and we would have two different kind of assessments. That would be highly problematic, and I have no idea how a judge would consider the audience to be taken into consideration when the audience is not actually limited in its own jurisdiction. So I have no idea how they would deal with that. As far as I know, the intent of the parodies was taken into consideration by the judges in the Belgian and French case law, rather than the actual public getting the parody. So it was more the intent of the author, the parodist, to be understood by the intended audience that was relevant, rather than the actual possibility for these audience to get a parody, which is problematic in different ways, because obviously the intent of the author will be highly problematic when the parody is akin to the one in indictment, for example, where you have a right-wing party, extreme right-wing party, trying to make fun of some people for politic purposes. So you can say the intent is actually, yeah, to be understood and to make fun of this. So taking into consideration only the intent of the author of the parodist might be problematic in that particular sense. So I don't know exactly, but I would assume that the fair balance principles would give some guidance after they're implemented in different ways. And why I'm saying this, because I had first thought regarding the fact that the target of the parody is well known is somehow, and this was in the literature, not in the case law, but in the literature, there was this idea that actually if the parody is well known, so the author is kind of more public and should enjoy a little bit less protection confronted to freedom of expression of others. So in the balancing, the idea that it is well known, it's supposed to be well known by the public, and therefore the freedom of expression would be a little bit more extensive in regard to these uses. And on the other hand, if I'm looking at the case law and the last decision that was issued in Belgium, so the one with the Mayad B that I showed on the last slide, actually the fact that the children would not get it was taken into consideration in the analysis of the fair balance, because actually this parody was intended to both the parents and the children, and therefore that in the analysis of the fair balance, that aspect was taken into consideration. So I do not know how you would deal with that, but the problem in the practice would be if you do have two cases on the same parody, which are supposedly leading to different conclusions in these different jurisdictions, that would be problematic. I don't know if that would happen, but if it has to happen, that would be dealt with probably within the fair balance analysis, and I don't know how a judge would deal with that. Regarding just and last comment on the questions by Julia Reda. Under Belgian and French law, they make no distinction between parody, quotation, parody, pastiche, and caricature. And my assumption is that actually the wording of the directive InfoSoc was borrowed from French law. And there was no distinction. This was just dedicated parody for the music, pastiche for the literature, and caricature for the visual arts. This was the understanding, and in the case law, there is no difference that is to be made. So the idea of getting the parody would still be a part of this discussion.
Thank you very much. Unfortunately, we have run out of time. Thank you for the presentations of the panelists, and also thank you for the questions in the chat room. We have to return now to the main session because the event continues. Thank you very much again for the participation.
Thank you.
Thank you.